Hi, this is Erica Marilyn. I'm the founder of Perfect Legal Video, and I'm very excited to have with us today Attorney Nicole Reeves Lavallee. And, Nicole, thank you so much for coming on the show today. It's very hot. And, just so that everybody knows, Nicole owns a family and real estate law firm in the Worcester area. And today we're going to be talking about witnesses at trial. And so welcome to the show.
Thanks for having me.
You are very welcome. So if I am going through a trial, which is already just a scary, scary word, let's just face it. I'm sure that most of your clients are like, when they hear the word trial. What can I expect?
Well, you're going to expect a lot of homework from your attorney, and you're going to have to do all that homework, and you're going to have to do it within a certain time frame. So let's start with that. Yes, the trial itself, even if you get that nerves when you go into court and you're like, oh my God, do I have to go in and do anything? No, you just stand there and look pretty at pre-trials and in motion hearings. And then I go, oh no, you got to talk. And they're like, oh, I thought you're my mouthpiece, not at trials. At trials, you're your own mouthpiece. I get to direct you, and I get to make sure that we go down the path that we want to, but you're the lead person that's going to make or break this trial. So it is an added level of stress, but the good thing is if your attorney is preparing you properly, it's not something to worry about. Your blood pressure will go up, but focus on what's being asked of you, follow directions, and move forward.
So my guess is the answer to this question is early, but when should I meet with my attorney? And should I do this alone?
You should definitely meet with your attorney, probably sooner rather than later. You may want to have one or two meetings with the attorney. One is, again, to make sure you have your homework assignments, you know the deadlines, you know exactly what you need to do and when you need to do it. The other one is obviously getting that trial prep, understanding what that trial is going to look like, what is going to be said, how things are going to happen, who's going to talk first, who gets to ask questions, how do I get to respond, all of those things that you're going, oh my God. Because finally, it does look like a little bit of what's on TV. Not with all the craziness, but it's more of what you see on TV than anything you've ever experienced when you're going into the courtroom on all the other times. So it is definitely something that you want to be prepared. The reality is it all depends on when your trial is. The sooner the better, but your attorney is going to say, hey, look, I want to meet with you, 2 months beforehand, and I want to meet with you 3 weeks beforehand. One, to kind of gauge where we're at. Two, if we talked about what needed to happen. Did you do your homework assignments? Do you understand what you're changing your wording to? How are you doing with certain things? Again, kind of putting reminders and saying, this is what you need to focus on, not focus on that. So all of those things are going to come into play. But again, have that conversation with your attorney specifically so you know how long is the meeting going to take? What do I need to do to prepare? How many times do you need to see me?
How do I prepare for this? I know you said there's a lot of worksheets and homework to do. Is there anything that you're in charge of doing? How does it work with the preparation for something as big as a trial?
Well, I'm definitely going to have my own homework. My biggest thing is making sure that once you give me the documents, I'm going to go through both your documents that you just gave me, as well as any of the documents that we already have in your file. I'm going to pick through each and every single page of every single document that you have, and I'm going to make a determination. That's the keep pile, that's the trial pile, that's the maybe pile, and I'm going to make those piles, and then we're going to talk and have a conversation and say, this is what I think we want to do, this is what I think I want to present. You're going to say, well, maybe I need to have this too, or hey, what about that, or why are we including that document? So we're going to have a discussion about that. In the meantime, I'm obviously going to also prepare for their witnesses to come in and testify. I'm going to prepare and review each one of those documents in gory detail because, again, you might give me a bank statement that has 5 pages on it, but I need to know each line item that I want to call to question, and I want to specifically point out to the judge. Me giving you a bank statement and not addressing it isn't going to tell the judge what you're looking for. The judge isn't going to look at it and go, oh, there's a magic thing right here, oh my God. No, my job is to point you out and go, judge, look at this document right here, this line, this one. And that's what you really want the judge to focus on. So again, that's my job to do that. My job is also to, again, look at what you have and kind of get a game plan as to what's the best order to put that in. Then obviously I'm going to prepare in terms of questions that I need to ask all the parties and all the witnesses.
Now, you do this all the time, so I assume you don't get a lot of stage fright, but I'm sure that your clients do, especially if they have to speak. And sometimes they don't even realize, like, we've talked so many times about how you let your lawyer do the talking, and now they have to talk. Are there any tips you have for people to get over stage fright of getting up there? Because how you speak in front of a jury can really change the outcome and how you appear. If you're confident, or if you're snotty, or if you're scared, or you seem unsure of yourself. And, you know, the other attorney is going to try to use tricks to throw you off, I assume. So, like, is there something in there? I know that wasn't in your questions, but I find this very interesting. I figure the viewers might too.
Yeah, I mean, I think the reality is there's always something. You know, I always tell everyone the normal tricks of the trade. Again, you're not using slang. It's not the cops, it's the police. It's not he, she. I have no idea who the hell you're talking about. Can you please, like, I might know the story inside and out. Judge is hearing it for the first time. When you start saying she, I have no idea who that is. Is that your daughter? Is that your spouse? Is that your mother? Like, who are we talking about? So it gets very frustrating. So there's certain things like that. It's, stay away from my child. It's not my child. It took more than one person to have this child. So there's a lot of those little tidbits that I'm going to give you. And again, that's part of, I'm going to prep you earlier on, and then I'm going to prep you later on, and I'm going to go, hey, why are you using that word? And every time I talk to you from the time I first say it, I'm going to correct you. And I'm going to scream at you at some point because you're not going to get it. And I'm going to go, what are you doing? So there's a lot of those little things that we're going to talk about. It's depends on what the situation is. We want to use different words. Some words have a negative connotation. And you want to use a better word because there's something that's more suitable. So go to the thesaurus and figure out what the right word is. So again, we're going to have that discussion, and that's part of trial prep, and it's going to be specific to your particular case.
Yeah, like if I'm dealing with my clients or I'm working with my clients, those are two very different sounding situations. So to move on, like, what are the documents that I should look over before a trial?
You should look over all of the exhibits. So all of the exhibits that I have determined, all of the exhibits that the opposing party has determined. If you provided answers to interrogatories, answers to production of documents, admissions, or if you did a deposition, you want to look through all of those. Reason being is because, some of these you're either testifying under oath or signing the documentation under the pains and penalties of perjury. So if I said the sky was orange in that deposition, and now I get on the stand and I say the sky is blue, the judge is going to be scratching her head and going, huh? Because opposing counsel is going to go in there and say, well, ma'am, didn't you say the sky was orange? Didn't you testify to that under oath? So are you lying then, or are you lying now? That's going to set you up. So you want to make sure that you're consistent with what you're saying in all of your testimony throughout the entire case.
Wow. I mean, it's a lot, and people do get confused and stressed out. They might say the wrong thing. And so let's move on to, like, if I do not have the honor of being your client and feeling comfortable in your knowledge and strategies, which luckily I have, and many people do, and they love your work. But if I don't, and I'm not your client, what can I expect?
Well, I think, again, I guess the question is, are you doing it pro se, or are you doing as a witness? So as a pro se litigant, you're going to be following the exact same standards of law as any attorney. So you need to be prepared. You need to know when you need to object. You need to know what your basis is for an objection. You need to know how to ask questions properly, or you're never going to get any testimony in. So long story short, don't do it pro se. In terms of if I'm doing it as a witness, so I am the mother of the husband in this particular case. All right. So the question is that person going to come in and do I get the benefit, if you will, of that person's attorney. Sometimes my answer is going to be yes if you're me, because otherwise I'm not calling you to the stand. So there's certain circumstances that I'm not going to call a witness. I will never call a witness if I haven't talked to them, if I don't know what they're going to testify to. There are attorneys out there that will do that, but I'm not one of them. So certainly you at least should get somewhat prepared as a witness in any trial, because you need to know what I have to bring, what I have to prepare for, what I have to know, how do I answer questions, where do I go? I mean, there's so many things that a witness, you're going to go and what? And you have no clue. So you do need guidance, and hopefully you'll have guidance from the attorney that wants you to go to the stand.
Now, before I ask this next question, I mean, the question is, do I need a subpoena to testify? Do I have to testify without one? And what is a subpoena, just to remind the folks out there that don't hear these terms every day?
So a subpoena is something that basically forces you to do something. So a subpoena could be, I want you, Worcester Public Schools, to give me records regarding Jane Smith, and I want them from zero or kindergarten through 5th grade, and I want them to include attendance, IEPs, school records, grades, anything else, right? So that would be an example of a subpoena. Or it could be, I want the teacher of the 3rd grade of my student, which happens to be Miss Smith, to testify about this child in this case. So that, again, it could be a documentation witness, or it could be a witness that needs to come in and testify. In terms of what that witness needs to do, is they need to bring whatever document is required. Do they need a subpoena? Depends on who they are. If they're a business or work for business, such as a school, medical providers, things of that nature, they are going to require a subpoena. Some of my clients' parents, witnesses, might go, I can't get the day off from work. I need a subpoena just simply so I can get the day off from work. Okay, that's fine. And other ones are going, I'm not coming in, you can't make me. Yes, I can. And that's what a subpoena does. A subpoena makes you take the day off and go to court to testify, because you were given a block of time to do this particular thing. And if you don't do it, then there could be a warrant for your arrest.
Well, I can see all of those different scenarios happening. And, you know, how often is it that people just don't want to come in, that you have to force them in with a subpoena?
It's actually little. It's not a lot. There's very infrequently do I do it. You know, every once in a while, like I said, I will get the family member that goes, I really do need a subpoena. You don't have to serve it, but can you at least send it to me? And I'll email it, and I'll do everything I'm supposed to, but I don't actually have it served by a constable or sheriff, because they're just going to show it to the employer, and the employer doesn't need a certificate of service. Why do they need it? They just want a document that says, yep, you're not doing it for stupid reasons, and you're doing it for a legitimate reason. Obviously, you know, people that work for the school system or people that work for medical facilities or stuff of that nature, they are going to want that document served, because again, they're not going to comply, because their employer isn't going to let them unless it is served on them. So it really kind of depends on who you're serving. But generally, once you are served, they will either say, hey, do you really need me? Can I produce the documents? Or, okay, I'll be there. So very infrequently do get pushback of, I'm not coming.
Well, you must love that. Now, what about the other party's attorney? Do we end up speaking with them at all?
Obviously, if you're my client, you are not speaking to the other party's attorney unless you are deposed. If you are a witness that is on the list, they have the right to call you. Would I recommend that if you're on my side to talk to the other party side? No. Why would we want to do that? You know, you're there hopefully voluntarily. Like I said, a lot of these positions are voluntary. So if you're a mom of a party or something of that nature, you're not going to want to talk to the other party's attorney. Don't give them a heads up. You're not required to, unless again they do a subpoena or a deposition. So the short answer is you definitely want to check with your person's attorney and make sure that they have to talk to them. But that being said, obviously, if it's a school, they probably will reach out, but they have different rules.
if I do have to go to court? Is it like I can make a reservation and show up at a certain time, or do I need to sit there all day?
Simple fact of the matter is, if you are somebody, and I know you're a hostile witness, and you're not a family member, and you don't really care what the outcome is, and you're like, why am I here? I'm going to try to give you a block of time. And I'm going to say it's a block of time. I'm going to say, okay, well, the trial starts at 9. I'm the defendant. There's 3 witnesses before us. And I know I can also go put my client on the stand beforehand. So why don't you come at 2 o'clock rather than 9 o'clock in the morning? So I may do something like that. But at least then you have a block of time, and then you might be sitting there for another hour or 2 hours or whatever. But at least it's not all day. Now, again, it depends on where we are. Certain witnesses, I have to call out of order, but I have to get permission from the court. I have to get permission from the other side to do that. So again, we're going to use our best judgment as to when we need you. We don't want people to have to sit there all day, but it's not exact science. So we don't get to have the final say as to what that really looks like and when we're going to get you called. Certain times that the judge will call other cases in before us, and we're going, can we start? We had a 9 o'clock trial and it's now 10:15. So that pushes us behind, which means you're going to be pushed behind. So again, not something that we can predict, but we can do our best to get you there, and only have to be there for your portion of the testimony.
So there's no way to just pick a time. You just kind of have to hope that you can get there and get in and get out. But there are a lot of things that delay, and if you're not the very first trial, you're probably going to expect delays.
Absolutely. And not even if you are the first trial, it doesn't mean you're going to start it right at 9 o'clock. The judge is going to do house cleaning. They're going to have other little cases that are 5 minutes here and 5 minutes there, and we're waiting for this, and I've got to go take a break. And so there's all these other little things that are going to come up. So 9 o'clock never means 9 o'clock start time.
So the nice thing about COVID, there's not many nice things about COVID, but one of the nice things is that a lot of travel time has been cut down by doing Zoom for many different business reasons. And I know court has utilized Zoom and also conference calling to help facilitate without people getting infected and that sort of thing. And I think a lot of that is kind of stuck. And it's really nice because you don't have to spend a lot of travel time and a lot of time wasted sitting in a courtroom. I mean, do you have to be there in person now, or is it different for a trial?
It is completely different for a trial. In the real world, guess what? We're going to make you come into the courthouse. So on very, very rare exceptions, and we really have to get permission, and we really have to know in advance that this person can't testify. So i.e., they're in a hospital bed, they're out of state, and they can't come in. Something of that nature. And again, we have to get permission. So it's not, I just don't want to come to court. No, sorry. Again, that's why I'm going to result in that subpoena. And the subpoena is going to say, you're going to show up at 225 Main Street in Worcester, and you're going to go to this courtroom. I'm not going to give you that option. So again, you're going to have to come to the courthouse, short of the attorney telling you otherwise, but plan on being there.
Well, this has been a lot of really great information. Is there anything that we didn't cover that you maybe thought about, or any gotchas that we should be aware of when it comes to trials and witnesses?
I think, the biggest thing is that you need to be prepared. You need to look at court orders. The court writes very specific orders as to when each thing is due. So when do you need to exchange your witness list? When do you need to exchange your exhibit list? Do you have the exhibits that are attached to the exhibit list? Are all of those things done timely? If they're not, then chances are you're going to be a sitting duck when it comes to trial, and the other party is going to move to strike all of that. So you really want to make sure that you look at those court orders, you follow them to a T, you give yourself ample time to make sure that you have it available so that you're not getting caught off at the knees when you go into court. I mean, I can tell you, I was amazed. I had an attorney that listed Teacher Smith on a witness list, and then she puts up John Dwyer, and I go, huh? Who's this? And I went, oh my God. And I couldn't, I was so dumbfounded, and I immediately jumped up and I object, and they're like, wait a minute, you're objecting to calling the witness? And I'm like, Yes. They're not on a witness list. They're not here. And they're like, well, it was somebody else in the school system. Miss Smith couldn't come. I'm like, that's not the rules. And ultimately, the judge did exactly what he was supposed to, is they're not on the witness list. Strike them. They're gone. And that person didn't get to testify to anything. But it was one of those things that I've never seen happen again. And it was just, oh my God, what just happened? And, you as an attorney need to know that, and you need to know how to handle those things. So it does happen. And God forbid we're ever in that boat. And again, opposing counsel never even talked to me about it. If they talked to me, maybe I would have let it in. But, again, you thought you were going to pull something over on me, and the judge did not take kindly to that.
I mean, you see that in the movies all the time, right? Here's a surprise witness. Oh, just came in. We were just able to find them, Your Honor. And they usually let it go in the movies. But I'm glad to hear that they don't do that in real life. And they shouldn't. I mean, you have the rules for the reason of bringing justice to people and knowing what to expect, and really being able to come up with good strategies based on the rules and the law. And you make those work for you and your clients so well, and I know everyone appreciates that. And we really appreciate all the information today, Nicole. Thank you so much for taking these hot summer days and doing an interview with us without your AC on, making a lot of noise. I know what that's like.
Thanks for having me.
You're welcome. And thanks everyone for watching. We hope you have a wonderful day, and we'll look forward to talking to you again next week.